seeing how the business will repay them. And there's certain governmental actors. There's the Office of the U.S. Trustee. If the company files Subchapter 5, there's a Subchapter 5 trustee. And Brooke, if you could go to the next slide, slide 11, key terms. And the takeaway from this slide is that there are certain key provisions that you should consider if you're considering a bankruptcy filing. And we'll discuss some of these in detail. But the second term is one of the more important ones. It's called an automatic stay. Outside of bankruptcy, if a company wishes to obtain an injunction against their creditors, they would have to provide a lot of evidence and briefs and make an argument to a court. And the court may or may not grant an injunction against their creditors. But in bankruptcy, simply by virtue of submitting papers to the bankruptcy court indicating that you wish to file a Chapter 11, you receive an automatic injunction. So if a creditor is taking any type of steps to collect a debt against your company, that injunction, for the most part, will prohibit them from doing so. It's automatic. It's a very powerful feature of bankruptcy, and I believe it's one that is original to the American system of bankruptcy. Another important term are a term called a discharge and a discharge injunction. A discharge is the kind of golden carrot of what you want to get when you finish bankruptcy. That's a release of your debt. And when I say release, I do not mean a complete release of your debt. Most of the times, a discharge is the agreement that the company has made with its creditors to repay them. Oftentimes, those agreements are, we will repay you at a reduced percentage of what we owe. And once a court agrees with that new treatment of debt, the discharge injunction will kick in. Similar to the automatic stay, it is another injunction that prevents creditors from going after the company as long as the company continues to abide by its agreements with them regarding repayment of their debt. And I believe, let's go to the new law that was passed by Congress. It's informally referred to as Subchapter 5. And Brooke, if you could turn to slides 12 for a few seconds, and then slide 13. And Linda, I'd like to pass this on to you.
Yes. Okay. So the Small Business Reorganization Act of 2019 was enacted in August of 2019 and became effective in February 2020. It created an entirely new chapter under Chapter 11 of the Bankruptcy Code. And because it's a subchapter of Chapter 11, it's called a Subchapter 5, or short, Sub 5. Know though the Sub 5 did not just magically appear, but is a result of hard work of a lot of people. It was a necessary change because of the contributions that small businesses contribute to our economy, as I discussed earlier. One of the biggest complaints of businesses in filing 11 is that it's so expensive and it's so cumbersome. So, you know, if you're a big company like J. Crew, Lucky Brands, Neiman Marcus, and all the mega bankruptcies that you hear out there, the fact that it's expensive or too cumbersome is not that big of a deal as compared to mom and shop stores that the Small Businesses Reorganization Act is intended to cater to. So Sub 5 is intended for small businesses to move through the bankruptcy process quickly and cheaply so that it can remain in business afterwards, which of course benefit the owners, the employees, the suppliers, customers, and others who rely on the business. So the SBRA, given COVID, it has become an unintended lifeline for small businesses who are considering restructuring due to COVID. It's definitely very debtor friendly. Next slide. So can any business file SEP 5? Well, they're to be eligible to file as a SEP 5, and I'm going to simplify. The entity or an individual has to engage in a business activity. It has to have debt of no more than $2,725,625. But with the CARES Act, in light of COVID, that debt ceiling has been increased to 7.5 million. And that 50% of those debts are from business activities. Okay. So by the way, this definition alone affects 40% of all Chapter 11 filings in the last 4 fiscal years, just to give you an idea of the impact it will have on small businesses. Okay, next slide.
Oh, and Linda, can I chime
Yes.
in really quickly on slide 14? Thanks. So this definition is interpreted broadly, and it should include most small businesses. In subpart 1, it says a person. So people who are sole practitioners or sole proprietors, I'm sorry, who are sole proprietors. An individual that has a business, performs some service, and it has not incorporated, those individuals are also eligible under subchapter 5. If your company has certain affiliates, those may be eligible as well. Part 2 references debt. When a company is considering whether it's eligible under subchapter 5, it has to include its secured debt as well. That can be somewhat tricky if your company, if you're a sole proprietor and you have an expensive house. Your house may be part of the equation. If you're a standalone company, you have to factor in your equipment, your trucks, things like that. That also factors in the definition of secured debt. So just some issues to keep in mind. And Brooke, please turn to slide 15.
Thank you. So it's quicker. How is it quicker? Well, a SEP 5 trustee gets appointed and the 341A mean of creditors is set within 24 to 48 hours. Everett, how in a regular 11, when is it set? Is it set within the 24 to 48 hours?
No, Linda, it's not. It's usually set maybe a few days later. Essentially, when a company files under Chapter 11, the Bankruptcy Code creates what's called a meeting of creditors. This is essentially a meeting where the company's creditors can come and ask questions. And the representative of a company appears and responds to some of those questions and gives an estimate of how they think they will repay some of their major debts.
And usually it's set later and not as quickly as you see in a SEP 5.
That's correct. That's
okay.
Subchapter 5 is, you can think of it as speed bankruptcy.
Okay, there we go. And along those lines, the U.S. trustee conducts the initial debtor interview within 10 days. And that's really quick as well. The meeting of creditors is approximately 21 days after filing, because generally it's much longer than that, right? Like 30 plus?
That's correct.
Okay, so the court also sets a status conference not later than 60 days. And the status report is due 14 days before the 16 days. So what I'm trying to convey here, if you get the sense, is that things move way quicker in a very expedited time frame as compared to an ordinary Chapter 11. Next slide. So it's also cheaper because there's no creditor committee unless the court orders otherwise. Just to give some background, not having a creditors committee is a huge savings because a creditor committee is authorized. Okay, let me back up. A creditor committee is a body of creditors that monitor and checks on the debtor's actions in bankruptcy. Okay, so a creditors committee is authorized to retain its own counsel, its own financial advisors, and other professionals. And here's the kicker: the debtor has to pay for the cost of that creditors committee. So not having one is a huge savings. Not having a disclosure statement is a huge savings as well. Think of a disclosure statement as like an offering memorandum that has all of the financials, the history of the business, the financials of the business, and some of its projection. Okay, that's a big undertaking to prepare such a document and to send it to all of the creditors of the debtor. So eliminating that document itself is a substantial savings. It's also cheaper because the debtor does not have to pay the U.S. trustee quarterly fees, and that is dependent on the amount of disbursements that the debtor make in the case. So it could be substantial depending on how much disbursement the debtor makes. And you get a sub 5 trustee whose job is to facilitate and develop a consensual plan. So that is a huge cost saving process, especially if the debtor doesn't have counsel who does bankruptcy regularly. Let's see. And in general, a sub 5 allows the debtor save money because it's so expedited. It's like Everett says, it's speed bankruptcy. So you get from the point that you file and get to confirmation is much faster. And confirmation is important because that gives you a plan to exit bankruptcy. The less amount of time you spend in bankruptcy, the more you will save. And that's the idea. Next slide, 17. Okay. See it. The sub 5 is more effective. There's substantial benefit. It's very debtor friendly in so many ways. Only the debtor can propose a plan, and that is significant because in the 11, creditors can propose plan, and there could be a big fight, and that can be expensive. The sub 5 limits it to just the debtor. Even if the debtor has been rebuked, only the debtor can file a plan. Okay, so what is a plan? A plan is simply a contract that provides for a treatment of creditors and their claims, and it replaces the pre-bankruptcy obligations with new terms. So in the simplest way that I can explain it, that's the plan. Okay, and once it is confirmed, it's binding on all of the creditors and the equity holders of the business. Okay, so having the debtor remain in control and propose the plan, that's a huge incentive to have debtors file a sub 5. And I won't go through all of this here. I will just, I'm looking at the time. I'm going to highlight the absolute priority. Okay, so equity owners of the business, like principals of the business, can actually retain their interest even if unsecured creditors are not paid in full. Okay. Prior to sub 5, in order for principals of the debtor's business to retain an ownership interest in the debtor, unsecured creditors have to be paid in full. With the sub 5, they do not have to be paid in full. Of course, there's other compliance, but that is key and that is substantial for a small business, because if it's a viable business, the principals want to keep this business and continue operating, but want to not necessarily or can't afford to necessarily pay all of its pre-bankruptcy or legacy debtors, creditors, that owe many 100%. Okay, so I think that's substantial. Is there anything else you want to add, Everett?
No, Linda.
Okay, all right, so let's see. Um, that sums it up for step 5. It's really exciting. It's very debtor friendly in so many regards.
And Brooke, would you turn to slide 20, please? So now we're going to discuss some of the benefits of filing a customary Chapter 11 case. And some of the benefits to filing Chapter 11 I've discussed before. For example, the automatic stay, which again stays debt collection actions against the company and the company's property. Another benefit is that the company is allowed to continue to operate while it's in Chapter 11. So the key decision makers of the company continue to exercise their business judgment and continue to make decisions for the company, unfettered by any second guessing by creditors, the bankruptcy court, or anyone else. And so that breathing spell is one of the benefits of Chapter 11. On slide 20, we've summarized some additional benefits. Because the automatic stay or that statutory injunction is in place, the company really has time to evaluate some of its debt. It has time to look at which contracts are favorable or unfavorable, and and decide whether it wants to get rid of some of those. For example, some companies have really unfavorable lease terms. In Chapter 11, they have time to evaluate and make a cost-benefit analysis. Is it cheaper to stay in this lease, or do I want to terminate the lease and move to a different facility and use the cost savings to repay the landlord? Things of that nature. The company still continues to provide services and produce product, but the automatic stay is still in place. So the company can really sit down and figure out if it wants to cure some of its old obligations. For example, taxes. Unpaid taxes are due. If it wants to cure the arrearages of the mortgage, any type of mortgage debt. And lastly, a company can consider whether it wishes to borrow money while it's in bankruptcy. And surprisingly, companies in bankruptcy are often able to obtain additional financing at competitive rates. And some of the reasons the rates are competitive is that lenders are familiar with the bankruptcy process and they know that there are protections for them. So sometimes lenders are willing to lend money to companies in bankruptcy. And Brooke, if you could go to the next slide, slide 21. And we've set 4 additional benefits for Chapter 11, including reducing interest rates on certain debt. Because a company has a breathing spell, it can really sit back and try and adjust some of the more unfavorable contracts that it may have. And finally, some companies file Chapter 11 because they want to sell all of their assets, and there is a very structured process to do so. Bidders are often comfortable bidding on assets in Chapter 11 because the Bankruptcy Code provides certain protections for them that they might not have under state law. So filing a bankruptcy case in order to sell a business is also a frequent use of Chapter 11 and a benefit.
Okay, do we want to?
And then I think we want to segue to slide 24, which is asset sales.
Okay, all right. We skipped over 23, which is the automatic stay that you have heard Everett said in many different slides. It's going to get repeated. It is the most beneficial um, aspect of bankruptcy. You do not get to see that in any of the other options that we're going to discuss. So that's substantial. In addition, there is the 363 asset sale. This is like a cleansing process. The debtor is able to sell aspects of its business, whether it's the real estate or FF&E or the personal properties in general, or substantially all of its assets, free and clear of liens that attach to those assets so that the buyer can buy um, the assets without worrying about the collaterals or the secured creditors who use those assets as collateral. So that is substantial. The other aspect of it is in a 363 sale, the local rules require what we call an overbidding procedure, which is like an auction in bankruptcy court. And that will allow the debtor to get the best and highest price for whatever it is selling. And if you can see that the chart there, the first step of it is marketing as you, if you would, outside of bankruptcy. And interested buyers would get this bidding package. You often see this in 11. And the potential buyers then go through their due diligence and determine if this is an asset they want to purchase. And then if they are interested in purchasing, the potential buyer then submits their um, offer, which then will, if there are significant offers or different offers from potential bidders, then it'll go to the bankruptcy court for an auction, okay, which is an overbidding uh, sale. And you probably hear that the mega bankruptcies a lot. And this is another benefit of bankruptcy that we definitely want to highlight. There are a whole lot more, but the automatic stay and the 363 sale are substantial benefits. Okay, let's go to next slide. Everett, typical life of a Chapter 11 reorganization.
Thank you, Linda. We wanted to provide to you kind of an illustrated summary of how a case progresses in Chapter 11. The first couple of, I guess, bubbles or stages, rather, consist of kind of emergency motions. Once a company files bankruptcy, I sometimes like to use I guess the comparison of a big gate comes crashing down. There's debts that a company has before it filed, and there's debts that the company has while it's in bankruptcy. Company will need court approval to pay any debts that were owed or become due prior to its bankruptcy filing. So companies often need to come into court on short notice and obtain court approval to pay basic operating expenses that were due before their filing, such as payroll or tax obligations, or tax withholding. Certain vendors may require cash on delivery. Certain suppliers may require the debtor to pay them for deliveries that are en route. And so typically a company consults with their bankruptcy counsel, figures out which type of orders it needs on an exigent basis, and obtains those orders during the first couple days of its bankruptcy filing. And so that description refers to the first two stages, as well as the third. The third stage is references cash management. Some small businesses have ways that they handle their cash. They may have agreements with credit card companies or processors. They may have certain discount reward programs. They may have agreements with their secured creditors that the creditor will sweep its payment out of their bank accounts. And so a company can continue with that type of procedure if it wants, and it would need to get a court order. So the fourth stage refers to process and special provisions for certain vendors that provide goods to companies. And then next we have the meeting of creditors and the status conference that we discussed in prior slides. And then we have the bottom row. Some of the more important features of the bottom row is that the company has to make certain disclosures of its assets, its liabilities, and provide a report to the bankruptcy court as well as the creditors of how it is operating. And then finally, we have the plan, which is the debtor's proposal of how it will repay creditors. And most plans offer a lower percentage of repayment than was owed prior to the filing, of course. And then once a plan is approved, there's a discharge injunction, which prevent creditors from taking collection actions or going after any of the assets of the small business as long as it is performing according to the plan. And so, Linda, let's discuss some of the pros and cons of filing Chapter 11. And Brooke, if you could go to the next slide, please. Thank you.
So some of the pros, the obvious two, we already talked about the sale, the 363 sale, and the automatic stay. But the other ones are that the debtor remains in control. Okay, so that's you just operate business as usual, except there are compliance issues and various other things that we will discuss. But that you are allowed to run your business as usual in a lot of ways. Of course, it's only usual after all of the first row that Everett talked about in the life of a Chapter 11. I think if I have to identify a time frame, after all of the first day motions, after the 341As, the status conference, then you have some breathing room, then you can continue to operate as usual. Another pro is that you get to reduce or discharge the legacy debts, okay, the pre-bankruptcy debts. You will be able to preserve the business name, the goodwill, and the customer base if you continue to operate and exit bankruptcy. And let's see, I think those are the highlights that I want to mention for the pros. But of course, with every benefit, there are burdens, and Everett's going to tell you about the cons.
Thank you, Linda. One additional pro that I think that we have omitted, which I think it would be negligent of us not to mention, is that companies are often sued. We typically see a lot of businesses that are being sued for wage and hour, alleged violation, lawsuits by various vendors, breach of contract actions. Bankruptcy filing, for the most part, places a stop to those lawsuits. And instead of using the company's funds for legal fees to litigate those lawsuits, bankruptcy would allow the company and counsel for the other side to sit down and evaluate how to resolve that suit, whether it's a payment over 5 years, or some type of mediated settlement, instead of having a lawsuit that may lead to a massive judgment and then collection actions. So I think the breathing spell for litigation is also a pro of Chapter 11. But there are some negatives to it. The process can be expensive, especially if there are very aggressive creditors that continue to file motions or documents that require the small businesses counsel to keep running into court or to litigate. That can increase cost. there is a good deal of record keeping and disclosure that the company will have to make in Chapter 11. Sometimes a small business does not document everything. It's some entities are more seat of the pants. Um, that's something that would have to change once a company files Chapter 11. Um, all the income, all the expenses have to be documented. The court would require profit and loss statements, balance sheets, financial records, a list of assets, schedule leases, schedule obligations, up-to-date tax returns, and things of that nature. So that can impose a cost as well. And one con to consider is that sometimes the compensation of the management of a company may be subject to scrutiny. For the most part, reasonable compensation is permitted, but sometimes certain bonuses, fringe benefits, creditors may question those. So that's another thing to keep in mind. So Linda discussed subchapter 5, and she indicated that it's a subsection of chapter 11. So Brooke, if you could turn to slide 27, we've contrasted some of the features of subchapter 5 with some of the features of chapter 11. And if a small business files under chapter 11, there's longer deadlines, as you can see in the first row, in terms of deadlines to file and confirm a plan of how it will repay creditors. Quarterly fees are owed to the Office of the U.S. Trustee. And there's lots of other rules that apply. For example, a small business in Chapter 11 will have to file what's called a disclosure statement, which Linda described as a description of how it will propose to reorganize. There's also a rule which is called the absolute priority rule, which sets forth certain requirements that the owners of a business will need to satisfy before they can retain their interest. And by interest, I mean their stock interest or equity interest. Requirements that must be satisfied to allow management to stay in place. And Linda, do you want to discuss briefly some of the requirements of subchapter 5?
Yes. So let me see, is that a separate list or is it in the sub 5? Okay, so instead of 300 days to file a plan in a sub 5, it needs to be filed within 90 days. And as we discussed, this is speed bankruptcy. There's a lot of savings, as I discussed, with not having the requirement of serving a disclosure statement. And there's no creditors committee in a sub 5. And there is no requirement that unsecured creditors be paid in full for management to retain equity. So the absolute priority rule, which is what we call it, it's pretty complicated, but essentially there's a strict hierarchy of payment amongst claims of different priorities. So one of those is that all unsecured creditors have to be paid in full before management can have an equitable interest in the business after bankruptcy. So that rule is eliminated. The other nice thing about sub 5 is that the administrative expenses, that is your attorney's fees, your financial advisor's fees, the accountant's fees, all the professionals in the bankruptcy case after it's filed, they can be paid through the life of the plan, which is 3 to 5 years, as opposed to a Chapter 11, which has to be paid upon the effective date. And usually that could be generally 90 days from plan confirmation, for example. So the ability to pay these administrative expenses over 3 to 5 years is a substantial benefit in a step 5. Let me see. Are we ready to move to the next slide? I'm looking at the time.
I believe so, Linda.
Okay.
Linda will now discuss certain non-bankruptcy options.
Oh, do you want to do bankruptcy options, slide 28?
Oh, I'm sorry, slide 28.
Yes.
I'm sorry, Linda will now discuss certain other options under bankruptcy. I misspoke.
Yeah. So Chapter 11, okay, let me just sum up. In bankruptcy, we have the Chapter 11 bankruptcy, the small business Chapter 11. Now, the step 5. There are also Chapter 13, Chapter 12, and Chapter 7 liquidation. Okay, there's really 5 bankruptcy options depending on the goals of the business owner. Okay, so if you're a business owner and you simply want to stop operating and just walk away without dissolving the business with the Secretary of State, for example, you can file a Chapter 7 liquidation. And I'm a Chapter 7 trustee, and I've seen those companies that just file a Chapter 7 liquidation. And the trustee is appointed and is required to liquidate whatever assets there are. There's no monetary limit for a Chapter 7 liquidation. Unlike a Chapter 13, if the debtor is a sole proprietor, then the debtor can file a 13 so long as it meets the unsecured debt limit. It has to be less than $419,275, and secured debts have to be less than $1,257,850. Okay, and if the debtor is a family farmer or a fisherman with regular annual income, it has the option to file a Chapter 12. Let's see. So those are all of the bankruptcy options that are available to a business. Okay, just know though that in a Chapter 7 liquidation, there is no discharge. And Everett earlier explained to you what a discharge is. And of course, these slides are available to you after the presentation, so you can look that up if you have any questions. Now, outside of bankruptcy, but still court supervised, there is a, next slide, 29, please, Brooke. There is still an option called receiverships, okay? This is a non-bankruptcy, but still court supervised way to either wind down a business or restructure the business, okay? Slide 30. So what is a receivership? Well, it is similar to a liquidating 7. Essentially, all of the assets of the debtor is put into the control of a receiver who is a fiduciary, a neutral third party, who then is charged with the duty to liquidate and pay creditors pro rata. Okay, it's very much like what I do. And in fact, there's a lot of Chapter 7 trustees who are also receivers. Now, sometimes in a receivership, it's not a straight liquidation, but the business can operate as a going concern. The receiver would then try to sell the business as a going concern. And the thing is, the sale may not be free and clear as you would see in bankruptcy, or it is not as clean, I should say. There is that option under state law. And the receiver would then propose new repayment plan and hire new management to run the business so that it could essentially exit the receivership, okay? Creditors like receivership in general because it's much more organized and it's inside the context of a court, most likely a state court, okay? Let's see. I think that the thing to note about receivership is that it's not just a tool for the incumbent management to install fiduciary in there and liquidate, but creditors and business partners may want to put a business into a receivership so that it can be liquidated in a very orderly fashion. So what are the pros and cons of a receivership? Well, the pros is that it provides protection of, many of the protections afforded in bankruptcy because it's in state court, it's in a court supervised setting. And generally, if it's just a wind down, the administrative expenses is probably not that high. Maybe not as high as you see in a Chapter 11. There's no creditors committee, there's no plan or plan of reorganization, no disclosure statement. But for every benefit, there are burdens. So some of the cons are that the management loses control over the operation of the business. A receiver who is an independent third party comes in and starts the wind down. Okay. The ability to sell free and clear of liens is not as defined as in bankruptcy court. And the other thing to note, because a receiver is much like a Chapter 7 liquidation, the receiver's fees are not capped as you would see in a Chapter 7 liquidation, right? Next slide. I think your turn, Everett.
Okay, thank you, Linda.
32.
Brooke, if you could turn to slide 33. So slide 33 references out-of-court options for a company that's having liquidity, financial problems. The first option, of course, is simply to dissolve, file a document with the Secretary of State indicating that the company intends to dissolve and wind down its operations. Second option is to propose an informal workout with creditors and to have the creditor to sit down with the creditors and essentially propose some type of restructuring plan. And lastly, we have a feature under California state law, assignments for the benefit of creditors. And under an assignment for the benefit of creditors, a company transfers its assets as well as debts to another individual or business to distribute. And there are pros and cons to each of these out-of-court options. And Brooke, if you could turn to slide 34, I'll go through some of the pros and cons very briefly. So the pros and cons for a dissolution. And Brooke, if you could turn to slide 34, it has a chart. Thank you. Some of the pros and cons of dissolving a business is that it prevents any type of disgruntled partners, managements, members from suing the majority. It gives notice to the world that the company is dissolving, so it creates some type of closure. And the company can't operate, but it can wind down. It can liquidate its assets. The cons are it does cost money to dissolve an entity. They often require counsel. And there are not as many protections as the bankruptcy code, a receivership, or an assignment for the benefit of creditors would allow. And of course, while the company is winding down, management remains vulnerable to litigation exposure. And Brooke, if you could turn to slide 35, please. So out-of-court workouts. Some of the benefits of those are they're very informal, they're flexible, they're private, unsupervised, and it does not have the stigma of a bankruptcy filing. Bankruptcy filings are matters of public record, and they can damage a company's reputation. And out-of-court workouts are fast. But the disadvantages of an out-of-court workout are that they depend almost entirely on the agreement of creditors. If a creditor is recalcitrant, an out-of-court workout may not work as well. And of course, there's no automatic stay. Management remains fully viable to litigation exposure. Brooke, if you could turn to slide 36.
Before you move on, Everett, I want to add that out-of-court workouts can be beneficial when it is negotiating in the shadow of a potential bankruptcy. So my firm as a practice generally would engage in these workouts prior to bankruptcy filing. So we have clients coming to the firm wanting or thinking that they want to file for bankruptcy. We usually advise them to at least try the out-of-court workout. So to me, it's a precursor to the actual bankruptcy. And creditors are much more willing to negotiate because they know that there's a possibility that the business may file for bankruptcy and they may get less under or in bankruptcy. Thank you.
And very quickly, Brooke, if you could turn to slide 36. And we have the benefits and disadvantages of assignments for the benefit of creditors.
And, oh, sorry, is this my slide? Sorry.
Oh, I believe it is. I'm sorry.
Okay. All right. An ABC is kind of akin to a receivership without court supervision. It allows owners to transfer the business assets and debts, as Everett say, to an assignee who is a fiduciary. It can be a company or a person who then assumes the responsibility of liquidating the assets and paying creditors. It's an orderly and graceful exit. It is an effective tool if you want to wind down a business in a low profile way. It's not very public. This alternative was used a lot during the dot-com downturn. And what principals like to do is to be able to put all of its assets and liabilities into this ABC and then start a new venture free of the old company's debts. And it's usually a right situation if there are not a lot of complexities in the business. So the pros and the cons, it's a simple transfer in a trust. It's definitely less cumbersome and less in administrative costs as you see in bankruptcy or even a receivership. It's generally faster and there's more flexibility, and of course is not very public. The cons though are that there's no automatic stay and that there's no court approval because remember this is out of court, it's an out of court option. But the other significant disadvantage is that creditors may enforce contractual provisions to make the ABC prohibitive. So you can't, it isn't an option depending on the contracts that you have with creditors. And of course, there's no sale free and clear of liens. I mean, they try. I know that assignees do this, but there's no court order protecting the buyer or even the seller, the assigner. And I think with that, we're ready to move to the next slide.
And Brooke, if you could turn to slide 38. And these are our last two slides, and these are just tips and words of caution. Depending on the chapter the company pursues, best to start gathering documents. Documents such as company's tax returns, certain financial records such as profit and loss statements, corporate documents, insurance policies, and ownership documents. These are all documents a company will need to present to its creditors if there's an out-of-court workout, or to the bankruptcy court if it chooses any of the options under the bankruptcy code. And Brooke, if you could turn to the next slide.
And sorry, is it my, oh, okay, all right. So I like to add that for all business owners, and this is what we advise our clients, begin with the end in mind, okay? Where do you want to take the business? Do you want to wind it down? Do you think it's a viable business? You just have to get rid of some old debts or restructure old debts. So whatever options you choose, don't delay, okay? And have an idea of where you're going to come out. Bankruptcy is a great option. And rather than just throwing in the towel and closing down, know that there are all these options out there, and particularly bankruptcy. But you have to make sure that you believe that it's going to be a viable business. So you can commit to making sure that you maintain full disclosure with the Office of the United States Trustee. You continue to comply with court orders, continue to maintain accurate financial records, continue to update insurance and licensing, and you have to continue to work with creditors towards a plan of reorganization. Okay, don't file bankruptcy just to delay the inevitable, such as a foreclosure or an eviction. Don't file it if you have some other purpose other than all of the benefits we talked about, and the idea is to exit bankruptcy as a viable business. And that's where I was going with begin with the end in mind. Where do you want to see the business going? Okay, and that will help you identify options that are most beneficial to you. But if you're going to choose bankruptcy, there are there are compliance issues that you have to make sure you comply with, and then Everett will tell you all about that. That's his sweet spot.
Not necessarily a sweet spot, Linda, but I do deal with those issues a lot. Slide 39 sets forth certain nightmare scenarios. If sometimes companies are unable to comply with the rules, some of the worst case scenarios is that the court could appoint a type of receiver called a trustee to take over the company's operations, or the case may be converted to a liquidation chapter or dismissed. But those are nightmare scenarios. And I noticed that we've gone 2 minutes past our time. I'd like to open up the floor to any questions that anyone may have that we'd be happy to answer.
Are we seeing any?
I don't see any questions right now.
Oh, perfect.
Yeah.
That was very good timing.
Yes, that's perfect. Thank you so much. We appreciate all the information. And this video will be available on our website for people to watch.
Oh, thank you, Brooke. I appreciate it. And thank you, Linda, as well.
Thank you. And we appreciate everyone's attendance, and hope that you find the information helpful. And again, we are available, at least I am, for any other further questions at a future time. Thank you.
Thank you.
Thank you. Bye-bye.